Okay, we're ready to get started.
Okay. Hello and welcome, everyone. My name is Dave Zapponi. I'm the Executive Director of ECHO, otherwise known as the Educational Council of Homeowners. We are based in San Jose with satellite offices in Tracy and Laguna Hills, California. Thank you for participating in the ECHO live stream event on Political Rallies at Your Front Door, featuring Tim Flanagan. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. ECHO is 47 years old, which makes us the oldest association representing the collective interests of HOAs in the state of California. It prides itself on providing quality educational programs to build stronger communities. But before we go on with the program, please note, this webinar is scheduled for an hour and a half. Please feel free to leave the meeting at any time. ECHOs or attendees will be muted during the presentation to help with sound quality and to assist the speaker in developing concepts. Please note that we use the chat feature for technical issues and the Q&A feature for content-related questions. You may ask questions throughout the presentation using the Q&A feature. We will be vetting and answering questions as they come in. Please be courteous and respectful to the meeting participants at all times. We reserve the right to mute or remove participants at any time and for any reason. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recording will, along with the presentation slides, will be emailed to each registered participant within 7 to 10 days. ECHO is a nonprofit corporation which has and strictly follows an antitrust policy. It is available for review on our website at www.echo-ca.org. Finally, none of what is being said during this meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish this specific legal advice, we encourage you to ask your attorney. Thank you to our sponsors who make this presentation possible, including Access Construction, our program sponsor, and Q&A sponsors, EnviroViews and the Levy Erlinger and Company, LLP, CPAs. At this time, I'd like to introduce Don Alonzo from Access Construction, who will say a few words. Don?
Hi, everyone. Good afternoon. We're really excited to be sponsoring this program today. A little bit about Access. We are a construction company based in the greater San Francisco Bay Area. We've been around for over 29 years, and we specialize in reconstruction, as well as we have a painting department, an electrical department. So we really like to think of ourselves as a one-stop shop for construction. So if there's any questions that you have, please feel free to reach out to me directly, and I'd be happy to help. Thanks.
Thank you, Don. We really appreciate your sponsorship today.
Of course.
Today's program, Political Rallies at Your Front Door, will be presented by Tim Flanagan, Senior Partner and Shareholder at the Flanagan Law Firm, APC. The Flanagan Law practice includes HOA General Counsel, enforcement litigation, and assessment collection recovery. Tim has been practicing law for 14 years. His past 10 years have been dedicated solely to the representation of HOAs. Tim is very active in the industry and recently had a case published in the Court of Appeals, which has made it easier for homeowners associations to pass CC&R amendments. Tim lives in San Diego with his wife and 2 boys. Thank you, Tim. We're looking forward to your presentation.
Thanks, Dave. Appreciate you guys having me. And I think it's a great program to put on. And especially after 4515 of the Civil Code was adopted, I think that we really all thought this was going to be a very big year, 2020, for political issues. It turned out to be more COVID related, unfortunately, but they do intertwine a little bit. So we will talk about that as we go through on the program. This is Political Rallies at Your Front Door. And Hannah put together a nice little picture there of a protest. Hopefully that doesn't happen in your community. And if you, it shouldn't, if things like that do happen, I think that there is already a question about what may happen if there is some kind of, you know, riot or something that goes on near your community. Obviously, that goes outside of any bounds that we're talking about here as far as meetings and assemblies go. You know, obviously, you want to call your local law enforcement officials if there's literally somebody at your front door about to bang it down. So what are the common issues that we see with free speech and political signs, political meetings with homeowners associations? Number one, we have, you know, just general free speech type issues. So we're not going to really get into this too deep because it's kind of boring. But you have a hierarchy of laws when you're talking about free speech rights. So we all know about the, you know, First Amendment, and that generally gives us, you know, the right to a freedom of speech and freedom of assembly. And then the state law was recently codified to really expand on what those rights would look like within a homeowners association. Other issues that you're going to see are, you know, local candidates who may want to run for the local office, or it could even be, you know, state or even federal candidates that want to run for office and they want to speak within the homeowners association. You know, you're not going to really have that big of an issue, I guess, if a local congressman comes down, but you might have a candidate who's running for a local school board who may have some interesting ideas as far as his or her candidacy, and those are the types of issues you would see as far as allowing them to speak within the common area. General use of the common area, where can people speak? Where can people put up their different political signs? How long they can speak for? How long can the signs remain for? Is this only during the election cycle, or is it all year long? And also other issues is you know, whether or not, you know, there is a website or other type of online forum, whether or not homeowners get to access those. We'll talk about those as well throughout the program. Signs, we talked about that. And then finally, you know, door-to-door canvassing. There's something that people do not generally like is when someone knocks at their door, but we'll talk about that as well. And then handing out flyers in the association's common area. Next slide. Okay, so let's talk about the free speech protections limitations. So touch on this a little bit. We have the First Amendment rights, and that's laid out in the Constitution. The First Amendment talks about, and we talked, I guess I skipped over this, but as far as the hierarchy of rules go, hierarchy of laws go, you have the federal law, you have state law, then you have local, like city or county law, and then you get into the CC&Rs. So that's how that would trump there. But the First Amendment's free speech rights have to do mostly with like public actions. And so how is an HOA really involved in some kind of governmental or public entity actions? Well, you know, there's a lot of case law, and in general, homeowners associations are kind of a quasi-governmental entity. And so that's where you can get some of the applications to free speech rights through the First Amendment and the Constitution. And you have case law that kind of talks about some of that. And then more specifically, though, in 2018, I think there was a stirring in the legislature regarding free speech rights as it particularly pertains to homeowners associations. And so the Davis Sterling Act, they added a section, Civil Code section 4515, that talks about assemblies and meetings and what the association may or may not do as far as limiting those meetings. And then there's also another section in the Davis Sterling Act, 4710, that talks about political signs, and that's been in the Davis Sterling Act for a number of years now. Then you also have your governing documents. So sometimes your governing documents might have restrictions on signs that can be put up. It might have restrictions on bringing in outside political candidates. It may have restrictions on certain types of meetings. Well, the governing documents are going to be trumped by the rights under the state or federal laws. But you're also going to, you do have those limitations in the governing documents. And then you also have local government regulations. And the local government regulations really pertain to really mostly safety purposes. So, you might have a county restriction or a city restriction talking about the location of a sign on a person's separate interest lot that may block a view of somebody who's driving or biking or traveling through the area. So those also are going to be sources of our protections and limitations for free speech rights. All right, so we just added this in here because we wanted to show, the actual words of the First Amendment. So Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, which is, we highlighted that, or the press, or of the right to, this should have been also highlighted, or the right of people to peaceably assemble and to petition the government for redress of grievances. So those are our main sources, and frankly, what our country was founded upon: having the freedom of speech, having the ability to meet with others and demonstrate and show a common goal to change ideas in our country. And obviously, ideas are changing all the time, and we're in a homeowners association where that's where people reside. That's where people want to gather and discuss some of these ideas. So that's the initial source of it all, and why we are talking about that as far as homeowners associations comes to the upcoming slide here, Hannah. Under 4515. So under 4515, they get a little bit more specific onto what the exercise of the rights are. So here, it's the intent of the legislature to make sure that members of homeowners associations or common interest developments have the ability to exercise their rights under the law to peacefully assemble and freely communicate with one another. And then it talks about with what issues with respect to common interest development living. So we're talking about common interest development living or HOA living. We're talking about issues that directly affect your homeowners association. So that would be if there is a vote to whether or not to have a special assessment or to pass a CC&Rs amendment, or if there's a new rule that's going about and members want to talk about it, or obviously the key one that you're going to see most often, candidates running for the board or maybe a committee. That's going to be with interest of respect to the common interest development living. But here's where we get a little bit more nuanced, is when they talk about social, political, or educational purposes. Political, I think we all understand what that is. Either you're for Trump or you're for Biden or maybe a third party. You're cheering for a politician. You want someone to vote one way or another on the mayoral race or the local congressman race. We understand what that is. But it gets a little bit more nuanced when we talk about social and educational purposes. So, for example, for a social, there's been a couple different social movements really recently in the last 2 or 3 years in our country. The first, as we all know about, is the Black Lives movement, or Black Lives Matter movement, I should say, sorry. And then also the Me Too movement. Those are pretty big social movements in our country. But we've had other ones over the period of time, but those are some of the newest ones. What are the rights of the association to prohibit, a Black Lives Matters types movement or a Me Too protest? We're going to get into that a little bit deeper, but I think when we're talking about social, that's what we're talking about here. We're talking about something that's outside of the regular idea of who's running for president, who's running for Senate, who's running for local Congress. We're talking about social issues. We're talking about pro-choice versus pro-life. We're talking about death penalty or non-death penalty, and how that would affect your common interest development and be an interest to those people who reside within the development. And then finally, for educational purposes as well. And I think that's also a bit nuanced because in my mind, that's where the HOA has got to take a little bit closer look at what is the difference between education and a sales pitch. So it's one thing, I know some attorney, give you this as an example. There are some attorneys that I know in Northern California, after the Santa Rosa fires, they put on a barbecue for all the people who had been displaced by the fire. And they promoted it as an educational event on, recovering or recouping your losses from the fire, and yeah, that was probably an educational event, but borderline, because at the same time, they're soliciting people to sign up for their law firm so they could sue PG&E. So that's where it's a little bit more nuanced. And we're going to talk about a little bit more deeper into this, but I would say in general, you're going to want to make sure that it's not a sales pitch, and you can have, we're going to talk about specific restrictions that you can have in your rules. But if it's just focused on purely educational, then that's fine. If it's a sales pitch, then that's something that could be prohibited within the under the law. Hannah? Okay, it looks like I kind of talked about these a little bit. So, public elections, that's pretty clearly going to be covered under this law. I think Black Lives movements or similar type movements would also be considered under the law. Pro-life versus pro-choice, now we're getting a little bit more difficult. What is the gathering going to look like on that? We haven't really touched upon this, but canvassing and that's specifically allowed under 4515 if it's done in a reasonable time, manner, hours. But that's door-to-door canvassing. And then obviously association elections, where we know that that's going to be covered and allowed under 4515, and then sales presentations is not going to be allowed or can be prohibited. It can be allowed, but it can also be prohibited. All right, so now we know 4515 says you may not prohibit these assemblies and meetings, but there are some exceptions under the code. And I think this is where it's key for you in your community on how you may want to address these issues. And I know a lot of communities have adopted what they call either a peaceful assembly policy or a sign policy to go over what the exceptions are and what is not allowed, and how owners may go about moving forward with having an assembly or having a meeting that would be not violating the code, but would also control some of these meetings, so people have so that it's remain peaceful, and then people can have a limit to where they can access certain areas. So number one, it must be peaceful. And I think that's important because, and I'm not getting into politics here by any stretch of the imagination, but there is a line that has to be distinguished between a protest and a riot. So if there's going to be any destruction of property or fires that are lit or looting or anything like that, that's obviously outside the bounds of what can be allowed. And obviously that would be a breach of both the code and of law, and that would be a violation of the governing documents as well. What also can you do? You can control reasonable time, place, and manner of the protest or assembly, I should say. So, for example, let's say that there's a mayoral candidate who wants to speak to the homeowners association as a larger association, and he's short on time and he wants to do it at, let's say, 9:30 at night. Well, maybe that's not a good time because of noise reasons. Maybe you want to control that time and say, hey, these people can speak anytime between the hours of maybe 6 and 8 or 6 and 9. When people are awake and they're not going to be bothered by an assembly at a wrong period of time. Reasonable place, again, we're talking about where you can, something that's within reason where you can have that assembly. So, you know, you have many different, let's say in your association you have different areas that could be the common area. You might have a common area street, you may have a common area auditorium or like a gym area, and then you might have a gazebo or some sort. Well, you really kind of control where that could be, depending on what your association looks like, what that place is. And, you know, if you can have the assembly or the meeting in the common area gym or a general meeting area, then that's probably the best place to have it, rather than having it on the street, which may impede traffic or people's egress and ingress from their homes. So you can have that restriction. However, what if you don't have a common meeting space for somebody to have this, and the only common area is a street? Well, then you might want to create or, you know, block an area that wouldn't impede as much traffic. You know, put out information to owners, or have the people who are going to have the assembly put out information to the owners how they can get in and out of their homes, so they can have their meeting or gathering. And then a reasonable manner too, just we're talking about here is, you know, what is this going to be? Is this going to be a march? Is this going to be a, you know, a festival? You know, what can be controlled here? When you're talking about like a festival or some kind of more of a party, that might not be the right type of manner or right type of assembly for various reasons, because it could cause damage to the common area or cause health and safety concerns to the owners. But, you know, having a peaceful march, that might be allowed, as long as it's controlled where the location of the march is, and there's given time to the owners to prepare, and that owners have a chance to get in and out of their homes in a reasonable manner. One thing I want to, and before you can switch real quick, yeah, Hannah, but one other thing I did not touch on in the PowerPoint that I would like to touch upon is COVID as well. So again, when we're originally looking at this is pre-COVID, and COVID has made a lot of changes to, you know, what to do if somebody wants to have a meeting or an assembly. And it's very it's interesting, because the law, the state order, the state public health order conflicts with 4515, which is also a state law. And I think the most recent state order says that there shall be no more gatherings of 3 or more households unless there's a stricter local requirement. But under 4515, it says you shouldn't have restrictions on gatherings. So what does the association do in that situation? I think in that situation, you know, I think you're going to have to, well, either way, it's pretty much a no-win situation, to be honest with you. But the route might seem the most reasonable here would be to require that that everybody who's attending this meeting and who's organizing the meeting are following the state's public health orders, and they're following all state laws, and then allow the gathering. I think it's going to be a difficult spot for the association no matter what. But I would hate, for example, a homeowners association to get on the 5 o'clock news because they stopped a gathering, and then they have to defend themselves as to why they stopped the gathering. And I think that COVID is a legitimate and reasonable reason. But if those speakers were saying that they were going to abide by social distancing and masks, then I think it would be a more difficult argument for the association in that situation. But I think that's one of those things where you have 2 laws that are state laws that conflict, and we don't know the answer to who would be right and who would be wrong, because we really haven't any cases on that. But you don't want to be, you definitely don't want to be the first subject who's a part of a case involving this issue. Anna? Okay, so this is talking more about the reasonable time, place, manner. So here we're talking about, this is key, this first one, are the restrictions content neutral? So again, when we're going to talk a little bit more about content and what the HOA should or should get involved in. But let's say the board is very, Democrat or Republican, whichever way. Let's just what doesn't really matter which route. And they shouldn't get into the content of what the other speaker is going to say. So what they're really talking about here is avoiding anything to do with the actual content of the speech or the assembly or what the purpose of that assembly is, as long as it's reasonably related to common interest development, living, social, political, or educational purposes concerning the members of the common interest development. I think that the restriction would be okay if it's talking about time of day, location, where the protest or meeting or assembly takes place, and the type of assembly it's going to be. Are the restrictions narrowly tailored? I mean, we're kind of getting to some First Amendment issues here, but be very specific on what the association's looking at here. Serving a significant interest, I think here we're talking about public safety concerns mostly. And again, you don't want to have a situation where there's an unregulated march through the streets of your community and people don't know what to do and people are getting mad at each other and honking at each other and getting into fist fights because they're upset about this protest or march. And so that's why you would want to really control the type of assembly ahead of time. Are there other ways to communicate the same information? Well, really the question should be, how should you communicate your restrictions to the community? And again, drafting a policy ahead of time with your legal counsel taking a look at it would definitely help that. So, I mean, it's going to help, number one, people who want to have these meetings and gatherings, they know what to do ahead of time. And it just creates a understanding of the responsibilities of not only the speakers and but the residents of the community and those who may be generally affected, in the other people in the neighborhood who are members who may be affected by the assembly taking place or not. And then one other thing on the, so another thing under content neutral, we're going to talk about a little bit, you definitely don't want to get involved into, oh, it's Black Lives Matters and we don't like that movement, or we don't like pro-life or pro-choice, or we don't like the speaker. So you want to avoid that too, but also avoid things like, okay, no red signs. You don't want to have that because obviously, we know that one candidate likes red signs. Or the same thing with no blue signs. So that's another, when we're talking about content, we're not only just talking about this actual language that's going to be used, but potentially colors or logos that are going to be used as well. Hannah, you want to move it forward, please? Okay, so how is this put to work? So, okay, if we wanted to back up and have a public assembly or an assembly type of policy or meeting type policy for the association, I think the number one thing you're going to want to do is make sure you're going to get the rules put together, and you're going to have to follow the same rule-making process that you would for any kind of other rule that you're going to adopt. And some of the common area amenities you're going to want to address are, we already talked about, using common area spaces. And I would include websites on this as well. If there's a common website that the association has, I would include pegboards, or if there's a common board where everybody goes to and looks for meeting notices. And if that's getting too filled with people's messages and people's flyers that they want to put up, or other messages, then you might want to consider having a separate public board. This includes, also public streets and public parks as well. I mean, not when I say public, I mean common area, parks and common area streets as well. That's where we want to put that to use and control, you know, when the time of these meetings can be, the place, and also the actual event itself. Handing out flyers. So we talked about handing out flyers. This is specifically addressed in the Civil Code 4515. And frankly, these people can be annoying. I don't think, you know, I haven't run into this that much under this new law, but I've run into it in my general life where people are handing out flyers to me, and that can be distracting. But again, you know, if somebody's going to hand out a flyer, and they're gonna have to, if you put a policy in place, get approval from the association first as to where they can hand out the flyer. So if they're going to be on a corner where there's a lot of traffic as far as cars or maybe some foot traffic, you know, that could be an area where you're going to have the handing out of flyers. You know, a lot of California communities, we don't necessarily have anything like that, you know, but let's say there's somebody who's handing out a flyer before people leave the gate of their gated community. That might be a place where they can handle flyers. And we're talking, again, same thing with other meetings and other gatherings. You know, this is going to have to be a flyer that's in the interest of the common interest development. It's going to have to be related to a political or social or educational purpose. So people who are handing out Avon flyers or, you know, flyers for their new gym, that can be totally banned and not allowed within the association. Door-to-door canvassing. Door-to-door canvassing, you see quite a bit. So if there's a member in your community or a resident in your community that wants to go door-to-door for, you know, knocking on the door for a political candidate, or maybe talk about one of those social or educational or association purposes that we discussed, again, the board can create a policy or a rule that everybody has within the community that limits the time and manner of the canvassing. So perhaps you say, okay, if you're doing a door-to-door canvass, you can only do it between the hours of, you know, noon and 7 p.m. or 8 p.m. You don't get out too late after dark, where, you know, people are getting knocks on the door and they're worried about who it is at the front door. Also, you might not have a rule that says no leaving leaflets or flyers on the door. The reason for that is, you know, you can cause the legitimate reason or reasonable restriction there would be causing garbage and debris within the community. So that would be a reasonable restriction there. Marches versus protests. We touched on this a little bit, but, you know, again, if somebody wants to have a peaceful demonstration or march within the community, and the association was able to really control where they were able to have this and the time and manner, that type of restriction would be allowed. Saying no to the march may also be allowed, but I think you're putting yourself under more of a risk of being liable under the law. But my argument for rejecting a march application would be that an owner or owners may be blocked from ingress and egress of their homes. So, you know, when you're going to limit the marches to, you know, common area, you know, streets, you know, maybe around a tennis court, golf course, that kind of stuff, that's not really going to impede traffic. Next slide, please, Hannah. So we talked about time, place, manner restrictions. Well, what can you not do? The code specifically says that you cannot charge a fee or a deposit to use the common area. So let's say somebody's going to have a political gathering, or they're going to have a meeting to talk about how you should vote to recall the board, and they're going to be in the common area clubhouse. There should be, the HOA shouldn't say that, okay, you're going to have to pay a deposit of $1,000 or $100. That's not allowed under the code. Or pay a premium or a deductible on the association's insurance when the common area is being used for purposes under the code. So again, I can understand why a homeowner association would want to have that happen, because let's say, for example, somebody is injured during a assembly and they want to bring a lawsuit against the association. The association might want to say, okay, well, if that happens, then the person who is put together the assembly should be responsible for the premium or the deductible for that policy. But that's specifically prohibited under the law. Similarly, you can't require them to have insurance either in order to have the gathering. That would also be prohibited under the law. Okay, we touched on this a little bit, but this is specific language from the code. So again, if there's public officials, candidates for a public office, or representatives of the homeowner association wants to speak with members, they may speak on any kind of matter of public interest. Again, notice how broad that term is. And I really want you all to, we all have our own specific beliefs and what we are, we think it would be a matter of public interest or might not be a matter of public interest. The key here is that I think the legislature, their intent was to be pretty broad with this and to allow a lot of free speech rights within the association. So regardless of whether or not you think that, recalling the board is the right thing to do, or a public official who believes in a measure that the association doesn't believe in, let's say, no on Prop, 246 or whatever, and all the board members think that 246 is a great proposition. Hopefully that's not a real proposition. I'm just making this up off the top of my head. But if that was the case, I think that's a matter of public interest, and the board should just stay out of that and not get into whether or not they think it's a righteous cause or a matter of public interest that they believe in. Okay, so that was public assemblies and meetings. And the second portion of this is non-commercial signs, posters and flags that can be put up within the association. So this is we're now moving over to Civil Code section 4710. And I put in political signs because that's what we're talking about right now, like a lot of political signs. But that 4710 says that the association's governing documents, which would include the rules, it includes CC&Rs, bylaws, and rules, may not prohibit the posting or displaying of non-commercial signs, posters, flags, banners on or in its owner's separate interest. So that's a key line there. So, well, yeah, so let's say somebody is in a planned unit development, and the planned unit development, includes not only the owner's home, but it also includes their front yard area. And somebody wants to put up a sign for the local race or whatever, or federal race, that would be within their separate interest. However, in the same kind of scenario, if that was in a condominium development, then that likely would be common area, and these signs, posters, flags can be disallowed or not prohibited within the common area. So that's key, is if it's in the common area, it can be prohibited, but if it's in their separate interest, then it has to be allowed under certain conditions. So what are those? Here's some of the more conditions. So there's exception that there shouldn't be. Oh, okay. Wait, that's going to be my next slide. I'm not gonna jump into that quite yet. The other thing is, what can the association do here? And I put up this we found this sign, Reagan-Bush, 1984. Okay, so that election, was 36 years ago. That was a long time ago. And we don't want to have that scenario where we have a Trump or a Biden sign up in somebody's front yard, in December or January, and it's looking rusty and it's looking terrible. So can the association set a reasonable time period for when you have to remove those signs if it's for a specific instance like this, like an election? There is no clear answer in the Civil Code under 4710, but I think if you look at other related codes within that govern certain type of residential use, such as mobile home parks and other case law, I think it would be a proper restriction to limit the time period after a certain event that the sign can be up. So, for instance, a community might have a policy that says signs can only be up for local office or for the election 45 days before the election or 30 days before the election, and must be removed within a week or 10 days or whatever it is after the election. I think there's something like that would be reasonable, and the court would back up the association's decision on that. What would not be reasonable? Again, we're talking about the reasonableness, so we're talking about what a reasonable person standard would be, and basically we'd be talking about putting this in front of a judge and letting him or her determine what would be a reasonable time period. But I think that if it's less than a week, that wouldn't be reasonable, because the election process goes on for a long period of time. As we know, in California, we've been voting for our elections since the beginning of October. So I think at least during that period of time, if it's anything shorter than that, it probably would not be deemed reasonable. What about setting the limit to the number of signs that are up? So we've all seen those yards where you have 15 signs. The person is clearly really into politics. They're excited about this election. They've got really strong beliefs. What can the association do on that? Again, there is no clear answer in the Civil Code under 4710, but there's a couple of cases that actually look at similar restrictions. I think one of those cases is Fourth La Costa versus Scythe, which takes a look at what can the association do with some of these yard signs, and a reasonable restriction to the number of those signs is something the association can do. Again, when we're talking about reasonableness here, oops, I see Henry just put something up about local. We'll talk about that in a second, Henry. I saw your chat. We're talking about reasonable. Again, we don't know the answer to what reasonable is. In that one case that I talked about, I think the reasonable limitation that the court looked at was one sign. They thought it was reasonable to limit to one sign. Is that going to be the same in today's time period? Maybe, maybe not. But I think that you're going to, in order to determine reasonableness, you're going to have to look at maybe the size of the property, some of the number of issues that are going on within that time period. And Henry put up that you might want to also look at your local, city, county restrictions. And Henry just puts up this Santa Cruz County Code section that provides that they should not, this is constituting a traffic hazard, and also be removed more than 10 days after the election, which they refer. So again, we're talking about time, place, manner. We're talking about the place of the sign. If for instance, and I touch on this a little bit, but if you put the sign up in a spot where somebody is driving around a corner and potentially might not see an oncoming vehicle or pedestrian, if there's a walkway, that's going to be prohibited pretty much I would say in every county in California. And different counties are going to have the time frame for when you need to remove the signs or how long you can have them up. So if you do want to look at your local county or local city restrictions as far as those go, that would help your determination for your community as to what would be a reasonable time frame for having the signs, and potentially the limit on the number of signs as well. Okay, other signs exceptions. So protecting public health and safety. Okay, and that's where we just talked about right then, where Henry was talking about, Santa Cruz County's guidelines. Obviously, if you have a sign up like that 34, well, that 34 sign would be prohibited under 4710 because it's made of balloons. But if that was going to block or distract a vehicle from driving down the road or somebody from crossing the street because it was by a crosswalk, then that would definitely be a violation of the code, and the association could restrict that place of the sign. But something a little bit more nuanced to consider here, and again, we want to stay generally away from the content of the signs. But what happens if somebody puts up a sign that is clearly, going to cause, issues in the community? For example, if somebody had, well, I'll put it this way. So we're talking about signs, and we're talking about 4710, and we're talking about display of non-commercial signs or flags. It talks about what, it specifically puts down the size of the sign or the banner or the flag, and it's designed for that country, for a country flag. So obviously we know that the US flag is allowed to be flown within our community under the civil code. And what about, but the question is, what about for, I had a community once that somebody was flying a Mexican flag up, and people were offended by that. They were down here in San Diego, right on the border, and a lot of people were really offended by that. Well, that flag is allowed under the code. There's, even though it's another country and we're in America, they can fly that flag. That's not a violation of state or federal law, and it fit the sign and materials, and it wasn't a public health or safety issue. But I had another community where it's a little bit more nuanced than that. Okay, it wasn't a Mexican flag, it wasn't a Canadian flag. It was a flag from it was a 1920 or 1936 German naval flag. I had never seen this flag, and I think most of you would be like, what is that? We don't know what that flag is. And I had to look it up because a lot of people, this neighbor was complaining about it, saying that it was discriminatory. And so so I go ahead and look it up, and that flag was flagged, no pun intended there, but was denoted by the Anti-Defamation League as being a signal towards white supremacy and Nazism and anti-Semitic. So there was a neighbor in the community who complained about it, and because of federal rules like HUD rules that require the association to investigate discriminatory actions against other homeowners, we requested that owner take down the sign, even though he claimed that the sign was just because he wanted to show respect to his grandparents or something like that. But we made him take down that sign just because we didn't want to violate federal law by discriminating against other homeowners. And we also didn't want to cause, violence or other health and safety issues within the community. Other signage acceptances, and this is strictly from the code, but you can have your sign made of paper, cardboard, plastic, cloth, or fabric, but you can't have it. You can't have it made of balloons. You can't have it made. You can't have it be put on certain areas. Can't have it be made of plants or other materials. So if you want to have a restriction against that, that's totally fine. And similarly, the restriction is only by signs and posters that are 9 square feet in size, or flags and banners that are more than 15 square feet in size. And again, when you think about 15 square feet in size, we're thinking 3 by 5, doing some 4th grade math there. And that's generally the size of a flag that you would see for, the country or the state type of flags. Hannah, sorry, I was rambling on. I like interactive. I like it a little bit more interactive, so I'm not rambling on so much. But okay, so what do? Your CC&Rs have prohibition against signs, or maybe against other gatherings and meetings, but the code allows it. Well, state and federal law control, and then you want to look to city and county ordinances, like Henry pointed out. You know, every county is going to have a different ordinance on what can and cannot be allowed. And then finally, you can look to the governing documents. But again, we're talking about, you know, First Amendment type rights here, and the state intent under 4515 and under 4710 is to really give those free speech rights to owners within the communities, within the homeowner association and common interest developments. Anna? Okay, so this is probably one of the more difficult issues here. So again, I touch on it a little bit with the flag example, but who controls the message? When you're approached or you see a sign or you're told about an assembly or a meeting that might be a message that you're not sure about, number one, make sure that you're controlling your personal biases. So again, somebody may be anti-Trump and feel like that is, you know, that's discriminating against them to have that sign. Well, no, I'm sorry, that does not fall within the federal guidelines for discrimination. And even though your personal bias might be against that candidate, you got to separate yourself from that and not get involved in making a decision on behalf of the association that's based on your personal biases. Again, consult with your experts. That association I told you about with the German flag from the early 30s, you know, we had to look it up and figure out what even it meant. And, you know, it didn't matter that only very few people knew what it meant, but the message was there and it was clear. And so, you know, we had to do a little bit of digging in that, but it's better to check with your experts to verify whether the sign may or may not be allowed, or the assembly or meeting may or may not be allowed, because it protects the association. They can now rely on the business judgment rule to protect against themselves if they are made personally or named personally in a lawsuit against the association. Reasonably and consistently enforce the governing documents. So we did talk about if the governing documents have prohibitions that violate the code, obviously you don't enforce those governing documents. But if you do make a social assembly or public assembly type of policy, make sure that you are requiring that owners follow those rules. So not, you know, say, okay, for candidate X for board of directors who nobody likes, we're going to make him jump through tons of hoops. But candidate Y, who we all love, and she's been on the board forever, you know, we kind of, you know, don't make her, you know, have 5 days in advance notice of these meetings. We just let her do it when she wants to. Obviously, then you'll be putting yourself at risk of liability. Draft policies and procedures, I think that's good as long as you're consistently and ready to enforce those governing documents. But it puts everybody on notice as to what their requirements are, how they can go get their message out, what is and is not allowed. It makes it that much easier really to control the process for everybody involved, including members and board members as well. And then check with legal counsel regarding compliance with state and federal law. You know, you just want to make sure that if you do have a policy in place, that you have your association's counsel review those materials to make sure that they are not violating any laws. And I'll put in there not only state or federal laws, but also local laws like city and county ordinances as well. So that's it. It looks like, oh, just under an hour. And so
thank you, Tim.
I appreciate that. Thanks, Hannah.
So we're gonna, here is Tim's email address. So if you'd like to contact him, be sure to write that down. And then of course we'll still provide these slides to you 7 to 10 days after today. But we're gonna move on to the Q&A session. And this is sponsored by Enviro Reviews and Levy Erlinger and Company. So thank you. feature. So I'll go ahead and start reading some of those aloud. And if you think of something, a question, feel free to shoot us that question in the Q&A feature. So regarding political handouts, this person understands that the residents of the HOA can pass them out. How about non-residents that may be allowed through the gate and pass out political information?
Hey, Steve, that's a good question. So we're talking about this code section 4515. We're talking about residents and members. So this doesn't allow non-residents to just go into a gated community to hand out flyers or slip them through the gates. We're only talking about residents of the communities who want to hold these meetings. But this would include residents and members of the community who want to bring in somebody from outside the community who to speak on an issue. We're talking about limiting rights of residents and members only.
Thank you, Tim. We've got another question here. Are residents allowed or prohibited by law to put up election signs in the common areas? And does the HOA need to have a policy about that if they do allow residents to put signs up in the common areas?
There is no right under the law to allow for a common area sign. And as a matter of fact, in the 4710, oh, Hannah, you deleted the entire question before I could read it all. But under 4710, that's one of the prohibitions the association can enforce, is the prohibition for a sign within the common area. And I think that the reason for that would be clear, not only for health and safety issues, but potential damage to the common area regarding where the sign is located. And I can't remember the second part of the question, Hannah.
Does the HOA need to have a policy about that?
Do you need to have a policy? You don't need to have a policy. I do think that these policies are beneficial to have. But again, like any policy or rule, if you're going to put together a set of rules, you got to make sure you're gonna enforce it and you're going to follow those policies or rules. Because what happens if someone drafts a policy, let's say you guys get all excited in your community, you draft this policy tomorrow, and everyone's following it through 2022. And then the board members leave and new board members come on and people forget that that policy was ever in place. And then some homeowner remembers it and then, brings an action against the association for failing to follow the rules or the policy. So as long as you're going to follow those policies, yes, put them in place. I think they're helpful generally. And they're helpful not only for the, boards, but also for owners.
Thank you, Tim. And so if I happen to do that again and click too quickly, if you go to the answered ones, it'll bring up the questions.
Oh, okay. Okay, thanks.
Yeah.
There you go.
No problem. So we have Stephen here that says, so you actually mentioned about reasonable times for signs, having them up for a reasonable amount of time before the election or and after the election. Does that apply to handouts as well? And they say, I assume these are any political vote, either through the HOA, local, city, or county elections, or national elections.
Right. Yeah, I think that would be the same. So if somebody was handing out a flyer for vote yes on Proposition 246 or whatever, and the election already passed, then what would be the purpose of him or her doing that? Again, when we're talking about that, it's going to be a little bit more nuanced because there is no direct answer to this under the code. And the case law and other code sections that look at this look at political signs, meaning, people who are running for public office or maybe running for the board of directors. But what about an ongoing movement like a Black Lives Matter or pro-choice or pro-life or Me Too? That is a question that's not really answered yet. But I think that if it's for, local, city, county elections, I think that saying that you can't hand out flyers after the election is over with is probably reasonable.
So the next one that we have, their board recently made a policy to prohibit offensive language. This is not defined any further. Can the Davis-Sterling Act section take precedence? So if somebody is offended regarding a social belief that I have different than others, can I still be punished?
See, John, that's exactly what I was getting at. The board and other homeowners shouldn't really get into the offensive language too deeply, okay? Because again, a Trump sign might deeply offend one other person and a Biden sign might offend another person. So you don't want to get into that aspect. You know, rather than offensive, if you put up something that was stated that, you know, violated public or federal state law or could cause a health or safety concern, then that would be a prohibition that could be potentially be enforced without violating the Davis-Sterling Act. Again, if somebody put up a Nazi symbol, you know, I don't think that the HOA, the HOA would be fully within their rights to require that to be removed. That's a little bit further, and I don't think that's what you're talking about here. But yeah, as far as the nuance of offensive, I would avoid that if I was the board and getting into what is and what is not offensive.
Okay. So Miguel had asked us for some clarification on the different types of events and social gatherings that you mentioned. Was that the association board, homeowner, resident, tenant, or a random person from the public?
Yeah, so again, Miguel, maybe I already answered your question with this, but it's only for residents and members of the community. So if let's say the local city councilman or woman wanted to speak in your association, you know, they could be invited in by a member or a resident, but they don't just have the right to go within the association and speak. Again, these laws, the Davis-Sterling Act is specifically designed for members and residents of the community only.
I think that kind of hops into the next question that Nancy asked regarding their clubhouse and hosting political events, that would still fall under basically what you just mentioned, that's only for residents and they don't have to open that up to non-residents.
No, I think it's two different things. So what Miguel's saying, I think, is that who can host these events? Association, board, homeowner, residents, tenant, yes to all those. Some random public person, no. What Nancy's getting at, I believe, is we have a very small community of prohibition against meetings. So does this mean, what can be the limitations? Can you limit the people who attend these meetings to only residents? So that's a different question. So if you had a local councilman or woman who wanted to come down and speak, and a resident invited them and wanted to invite the local, you know, Democratic or Republican, you know, chapter to hear this person speak, what can the association do there? I think in that case, you know, the association under 4515, that member can be allowed to have that event, even though outside folks are going to be coming into the event, because that is a matter of public interest to hear a local congressman or councilman or woman speak. So you consider, so limiting that to members only, can you do that? Sure. But I just think that you would be subject to judicial scrutiny and potential liability in that case to prevent outsiders from joining that meeting if invited by a member or resident of the community.
Thanks, Tim. Let's see, the next one. So can an HOA require that someone holding a rally or protest or a speaker add the HOA as an added insured to their HOA policy?
Yeah, we touched on that a little bit as far as the insurance issue.
Mm-hmm.
You cannot require them to carry insurance. That would be prohibited under 4515. A more interesting and nuanced question, I mean, sorry, Carolyn, sorry, that was a good question. It sounded bad when I came out, but to me, a more nuanced question that James had is requiring a person or organization holding the event to provide for trash cleanup or security, because I don't think the code really gets into that. You know, I think that if there was a need for security, you would really have to demonstrate the reason behind having security for that event. And it would have to be, as we talked about, enforced neutrally throughout the association. So if you had 10 people show up for a meeting that was a Black Lives Matter movement and you had security required, but then you had 10 people show up for the, you know, vote in favor of Ms. Smith on the board and no security was required, I think that would be a questionable decision by the board and subject to liability and challenge. Trash cleanup to me is probably a little bit more straightforward. The owner is going to be responsible for any common area damage, regardless, you know, of whether or not they can have that meeting. If they damage a common area, that person's going to be responsible for it.
Awesome. You've got 2 questions there. I skipped ahead on one of them on
Sorry.
accident.
Yeah.
No, you're good. No, good. That was great. I did get one via email. So you kind of touched on this already, but I just want to make sure that this person has a clear understanding. So this person has requested the removal of a couple of Black Lives Matter signs and windows by homeowners. Do they have the right to enforce this restriction?
Is the reason because, well, I guess the person's not there, so I can't really talk. But if the reason is because,
it says there CC&Rs prohibit signs except small realtor signs. That might give some more clarification.
So under 4710, which I'm looking at right now, the sign, non-commercial sign may be displayed from the yard, window, door, or balcony of the separate interest. So to require somebody to remove that, you're looking at it because presumably the board thinks that the Black Lives Matters movement has bad issues with it. And so now you're getting into the message, the person's already protected under 4710 to have the sign up. You know, I think that the HOA is really treading lightly on and maybe being subject to liability here for doing that. One other, since we're talking about this, another scenario that just happened recently to me is one owner put up a Black Lives Matters banner in their window. So the neighbor across the street put up a Trump banner in his window. And so then the guy who put Black Lives Matter put up another sign that said, expletive the police. Expletive the police. That's I don't think that is something that would be a public interest, and you know, arguably you know, could cause issues with public health and safety, and potentially even violate, you know, state local law. I think something like that would be a lot more enforceable than a movement such as Black Lives Matters. So it is nuanced though, and I would talk to your legal counsel before making these decisions.
Okay, thank you, Tim. And the person that emailed me, if you want to respond or have any further questions, just feel free to email them to me. Okay. If a space in a clubhouse is already reserved, this code 4515 cannot preempt a reserved space for a non-political event for public interest. Is that correct?
Yeah, so that's what, John, that's a good question. So that's why you might want to have a policy in place. So if, for example, somebody reserves the clubhouse for a Halloween party, Halloween gathering, and it's not COVID-19 anymore. So next year, or you know, we have a vaccine, and we want to have a Halloween event in the clubhouse. Well, just because a person comes along later on and says, oh, well, you know, I want the local congressman or woman, or I want the board president to come in and speak on this association issue, that 4515 doesn't trump that the non-political event. So that's why you could say that the person can reserve a clubhouse as long as it hasn't been previously reserved by another owner. And they can hold that event on November 1st or something.
Thank you for the question and answer. Our next question, non-residents. I think you already touched on this one, an association preventing non-residents from attending. Okay, yeah, that one was already addressed. Can these policies take the form of rules so they don't require amending the association CC&Rs?
Yeah, I'm thinking of a policy or a rule making procedure here. Amending the CC&Rs is terribly complicated, time consuming, and really unnecessary because there's already code sections in place that address some of these issues. So having a rule in place, you know, presuming the associations, you know, has a very broad rulemaking authority under the governing documents would be the way to go.
And this one, I think we answered this about they have a gated community and people want a literature drop for the election. So non-residents.
Yeah, non-residents. If it's a resident who wants to go and put on leaflets around, again, when you say literature drop, I would also be careful on that. Again, if somebody's just leaving a flyer on somebody's front stoop and that's blowing around, I mean, that would be a legitimate prohibition. Handing out flyers to people and they're actually taking them, can't prohibit that. Knocking on someone's door, you can't prohibit that. But just leaving leaflets around, that could be prohibited under a policy.
So this question, can one guideline for political signs and banners include no profanity or offensive language? I think you touched on the offensive language.
Touched on the offensive language, but just so we're clear, Helen, yeah, so we talked about profanity or offensive language. If you're talking about swear words, right, or all the other vulgar language that everyone just knows, you know, I hate to quote that old Supreme Court case, but Supreme Court case a long time ago looked at this pornography issue and they just said, I know it's you know, illegal when I see it, kind of deal. So something like that is fine. But I don't want to get into, what I don't want the boards to get into is whether or not a movement itself is offensive. That's where you're towing on some lines, and then you might want to talk to your legal counsel about it. So again, we have Me Too, we have Black Lives Matters. They're two popular movements. Well, you know, but there could also be some right-wing movements as well. You know, like a Tea Party movement. Is that offensive? It could be offensive too, depending on what side of the aisle you find you sit on. But the interesting issues are, you know, borderline groups. Well, and there's a lot of borderline groups out there. We all know this. Before you ban a sign or ban a group from speaking, reach out to your legal counsel, because again, I think it is very nuanced on what you do and what you should not do.
I'm going to jump down, Tim. So regarding the swear words, can a person be fined?
Can a person be fined for swear words? I mean, I guess suppose you're pushing it. So, you know, I suppose you could say it's a nuisance. You know, someone one time got upset and said, you know, a swear word to somebody else. You can't. I probably wouldn't advise a community to go after that owner. If a person's constantly swearing in the common area, you know, that could be a nuisance. And you know, then the bottom line is there's swear words and there's certain language that isn't protected. We didn't really get into that too much, but that isn't protected under the First Amendment. And so, you know, defining what is offensive or not, you know, that isn't going to be protected. A swear word is not going to be protected by the First Amendment. Yelling fire, for example, in a movie theater isn't going to be protected. So, but it's going to be really nuanced. So, you know, again, I hate to say this, but really, if we're talking about nuanced issues, you should really check with your legal counsel.
So would removing a minor from events, if they're using swear words, would that fall under that same answer?
Removing a minor, so somebody who's under, okay, so you're removing someone, how would you remove them, Hannah?
Oh, I don't know.
Grab
their parrot.
So let's say you have a meeting, an assembly in place, and I would not even, once that meeting's in place, I really wouldn't get involved in a violation of that meeting. If people start chanting a swear word or something, you know, I would stay away from you know, going after them during the actual meeting. Maybe afterwards, that's when you reach out to the person who held the resident or member who held that meeting, and maybe address it on the back end. But I definitely wouldn't remove somebody from a meeting because they're under 18 and they're saying a swear word. I just would not get involved with that. I wouldn't recommend that, at least.
Thanks, Tim. So here's one. Can an HOA board prevent political matters or candidates from being put on the agenda for monthly meetings? Is it better to have 1 or 2 special board meetings just for political matters in order to meet the requirements of Civil Code 4515 or other laws?
Yes, thanks, Steve. It's a really good question. Yeah, you don't want to have that. Your monthly meetings should be addressing business matters and conducting the business of the association. So get that done with. And again, if you put up, you can have a town hall meeting. So, if you want to have a special board meeting for political matters, that's fantastic. But I think that's what the code is actually touching on, is that you don't have to do something like that. The members can put it on themselves. So the board doesn't really need to get into it and say, we're going to have, somebody come down and speak on the election, or we're going to have a town hall meeting for the election. Can you do that? Yeah, I think that's fantastic for your community. Do you have to do that to comply with 4515? No. But this allows owners to do that themselves and to set aside a special meeting for residents of the community to talk about these issues.
Thank you. And the inspector of elections is including statements from nominees, but
You skip Miguel.
oh, sorry, my scroll bar. So residents and tenants are being, what is HO?
Homeowner rights.
Oh, homeowner rights to common area use.
Yeah, so the code does say residents or members, Miguel. So I would include that as being tenants.
Okay. Now to the one.
Now, well, that's the one thing I would say though. If you have like a short-term tenant, if your governing documents allow for weekend rentals or vacation rentals, and somebody's there for a period of time where they're not a resident, then they can't just rent into that community for the weekend to hold a political rally. That would be not allowed. But if someone is a long-term resident of 30 days or more and they consider themselves a resident of the community, then that would fall under 4515.
Okay, so our next question, the inspector of elections is including statements from nominees, but specifically excluding statements from other non-candidate members in the election/ballot package. Please comment.
Yeah, so under there, we're probably taking a look at some of your election rules as well, James. But yeah, generally what you're doing at the election itself is just having the candidate statements, and they have the right to have the candidate statements read out loud. At the open forum during the ballot counting period, or during the open forum at that membership meeting, the members who want to speak about any kind of homeowner issue, including the various members who are on the ballot, they can speak then. But there's no reason, there's no separate right to allow that period of time by the inspector of elections when they're counting the ballots to be included under 4515.
So from Christy here, if there's what if a member angry with the association or board of directors decides to put an offensive sign such as the F word, the homeowners association, and exert their freedom of speech? What are their rights there?
So we touched on this earlier, Christy, but
Right.
Again, instead of using offensive, if you say profanity, no profane language, profane words, that's going to be a reasonable restriction. The First Amendment, freedom of speech, does not protect against those type of words. So yes, you're fine. You don't need to have that word up all over your community.
So if the person decides to, okay, I won't use the F word, but I may say the homeowner association is dumb, would that still be as
Yeah, that would probably be allowed. Yes, I think that would be that's not going to be an F word or a profane language that would be allowed to be restricted. And so I think that if you brought that, if the owner challenged that and they said that they wanted to put up, they thought the homeowner association was dumb. Dumb's not an offensive word. And I think that the court would kind of back the homeowner there.
Okay, thank you, Tim. Okay, so an HOA board cannot have a rule that prevents a member from knocking on doors when passing out flyers, just allowing the flyers to be put on the door or dropping them on the sidewalk or put on an entrance gate to the resident.
Yeah, Steve. So again, if you're going to have you can't have a rule saying you can knock on the doors only between certain hours. So, you know, when someone at 10 o'clock at night knocking on the door, or at 5 in the morning or 6 in the morning or something like that. So you can have reasonable time for knocking on doors and canvassing. Yeah, so yeah, you can have a rule for that.
And what about a homeowner that just puts up a no soliciting sign on their door and they just don't want to deal with any of it? Would that essentially, that person shouldn't be going to their door anyways?
That no soliciting sign is not going to really have any effect on whether or not a person wants to knock on the door or has the right to do so. So no, the answer is no, Anna.
Gotcha. Okay. All right, is there any other questions? I think we've gotten through all the questions in the Q&A. Let me double check the chat and make sure I didn't miss any there. Don't see any there. Well, thank you everyone for your questions, and thank you, Tim, for your time and expertise throughout the presentation and for the Q&A. I really appreciate it.
Thanks, Anna. Thanks, Dave, for putting this on.
Bet. Thanks to everyone showing up. We appreciate it.
Yes, and thank you to our sponsors, our program sponsor, Axis Construction, our Q&A sponsors, EnviroViews and Levy Erlinger and Company, and also our dynamic sponsor, the GB Group, Construction and Painting. Okay. And coming up next Tuesday is the route to new rental restrictions with Lori Poole and Alex Sohal. So we hope to see you there. You can register for that on the ECHO website. And also for those of you that joined us for the 2020 HOA University and Expo, if you happen to have attended, or maybe if you didn't attend, we do have a wrap-up party coming up this Friday, where we'll be just wrapping up the event, getting some feedback, having a beverage of choice, and also giving away some great prizes. So we hope to see you there, and you can also register for that on the ECHO website under events. And thank you all for joining us today, members and non-members. We do offer this to you for free. And if you're not a member, we do encourage you to become a member of ECHO. There's a lot of great resources that we have for you, and we'd love to have you part of the ECHO membership. And if you would like to become a member, feel free to email jprice@echo-ca.org or call our office at the number provided. And thank you all for participating and your great questions and for your attention. And thank you again, Tim.
Thanks, Hannah.
All right, have a wonderful day.
Bye, everyone.
Thank you, Don. Bye-bye.
Bye.